So I'm Shanna Welsh-Levin, your Southern California real estate attorney with SoCal Realty Law. At SoCal Realty Law, we protect real estate investors and real estate professionals. We provide litigation services, eviction services, and also property transaction services, mostly for residential properties. That is residential, including multifamily, so anywhere that people live. I have a lot of experience since 2004 in real estate law. I've only ever practiced real estate law here in San Diego County. I also am a licensed real estate broker, although I do have to renew, have to complete my continuing education right now. But I maintain my broker's license and am a member of the realtor organizations. And I also have a nonprofit. So not only are we on one side providing landlords with services, but on the other side, I like to participate in providing some form of housing for women and women with children who are homeless and need some emergency shelter. I'm happy to tell you all about that at a later date, or go to amicus.org and you can learn all about that. So today we are going to recap the City of San Diego tenant protection regulations. And this went into effect on June 24th of this year, and I've presented on it many times. Each time it's a little bit different. Each time I learn a little bit more about it. So I'm gonna try to run through it as quickly as I can and give you guys some time to chime in and give me your observations and your questions. All right, so the new tenant protection regulation does replace the old tenants' right to know regulations. It actually replaces that section in the San Diego Municipal Code. It renames it. And so the old regulations are no longer in effect. And the new regulations are an enhanced protection of for tenants. It goes into effect sooner. It is broader in its protection. And the city actually has asserted that it supersedes the state tenant protection regulations, which I think that is disputable. And so we tend to make sure that when we're considering compliance for a landlord, we are complying not only with the City of San Diego regulations, but also with the State of California regulations and any other programs that may be in effect, like Section 8. Okay, so tenants that are protected by the new law are those who are continuously using and occupying a non-exempt rental property, residential rental property, for more than 30 days. There are many exemptions to the law, but the exemptions, some of them are automatic and some of them need to be claimed. There's also an interesting exemption. It's not listed as an exemption, but in the definition of the statute, it says that it does not include a lease for a fixed term of 3 months or less. And that includes any extensions of the fixed term or of 3 months or less. And so the question that comes to mind is, are month-to-month leases exempt? This requires some legal research and finding the definition of a fixed term tenancy versus a month-to-month or a periodic tenancy. And so I did some of that research for you, and here's what I found, because this is really ambiguous. I think there is some gray area and some disputability in here, but a fixed term can be for any stated period of time, i.e. it could be a number of weeks or months. It could be a single year or several years, but the term must be specified in the lease. Or the term must be capable of a certain determination from the lease provisions. If no fixed term is ascertainable from the lease, then it is not a fixed term, and it will be deemed a month-to-month tenancy. So a month-to-month tenancy is not a fixed term. But how do you know the difference? So to distinguish a month-to-month tenancy from a tenancy for 30 days, it really does come down to, in my opinion, it comes down to how the lease states the term. I also feel strongly that it comes down to whether the lease provides for an automatic renewal from month to month. So a lease for 30 days, quote, if you say this lease is for 30 days, that is a fixed term tenancy. But if you say this is a month-to-month tenancy, then that is a periodic tenancy and it is not a fixed term. So also the definition of a lease under the San Diego regulation is a written or an oral tenancy agreement. So it does not have to be a written agreement. So a month-to-month could be a verbal month-to-month, or a fixed term for 30 days could be a verbal fixed term. We'll just leave it at that because we could explore that for a while longer. The list of automatic exemptions are hotels and motels, short-term residential occupancy, STRO. Those are our vacation rentals. Then we have deed restricted affordable housing and subsidized rental housing, but Section 8 is specifically exempt from the statute. So the city intended not to include Section 8 as an automatic exemption. A property that is of the type that the exemption may be claimed, like a single family residence, may still be exempt if it's a Section 8 tenant and if the exemption is properly claimed. Okay, mobile homes, nonprofit hospitals, religious facilities, extended care facilities, elder care facilities, and transitional housing, as defined, it has to fall under the proper definition, are automatically exempt. Dormitories, and then roommates of an owner, as long as the owner is not renting out more than 2 rooms or 2 ADUs or 2 junior ADUs on the same property. It can also be an owner-occupied property with up to 2 mobile homes on the property. Also, an owner-occupied duplex is automatically exempt, and any property that is less than 15 years old. Okay, then we have single-family residences. Single-family residences are not automatically exempt. The owners have to claim the exemption. This is very similar to the procedure that is used for exemption from the rent cap and just cause laws, the state of California rent cap and just cause law. That's the Tenant Protection Act of 2019. But the notice of exemption that needs to be given to the tenant in order to claim it is different. So you may have a single family rental that you claim the rent cap and just cause exemption. That does not automatically carry over to being exempt from the San Diego ordinance. You now have to provide the tenant with a new form that has specific exemption language that references this law. And I have a form that I've created that puts the two together. So after January 1st, 2024, if your property is exempt, you must include the language in the lease. The exemption language as of today for new leases should be included, but I think that a notice of exemption along with your new lease would also be fine. We've been providing this notice with new leases that we've been doing and providing it to landlords. And if you have an ongoing lease that already exists, all you have to do right now is provide the tenant with the notice of exemption. If your property is not exempt, then there is something else you need to provide, which does include, there is still a notice that needs to be provided and a tenant protection guide. We'll talk about that in a moment. With regard to single family residences, owners who cannot claim the exemption are real estate investment trusts, REITs, properties that are owned by a corporation or an LLC if a member of the LLC is a corporation, or in a mobile home park. Mobile home parks cannot claim the exemption. All right, so within the city of San Diego, for non-exempt properties, the protections are now effective. The tenants are protected immediately at the beginning of the tenancy, unless it's a fixed term of 3 months or less, or exempt for some other reason. This is very different from our rent cap and just cause state law, because the rent cap and just cause law only attaches to the tenancy once the tenant has been in the property for 12 months. So, you know, right at that 366th day, that's when the rent cap and just cause protections attach. But in the city of San Diego, these protections are immediate. The old San Diego law only took effect after 2 years. So this is a drastic change. Another big change, really big difference between the new San Diego law and all other tenant protection laws is that now we have 3 notices for a at-fault just cause. If it's a curable breach, so those are all technical terms, at-fault just cause. Let's start with just cause. If you are not exempt from the laws, you have to have just cause in order to terminate a tenancy. Just cause is maybe at fault or no fault. At fault means that the tenant has done something and they are at fault for the termination of the tenancy. The typical one would be non-payment of rent. So non-payment of rent is what we call a curable breach. You have to give the tenant a notice of their right to cure the breach, and that's usually a 3-day notice. They have those 3 days to pay the rent in full, and then they may stay, and you cannot evict them if they've cured the breach. Now with the San Diego regulations, you have to give the tenant an early 3-day notice to cure, and that is not to cure or quit. That notice does not terminate the tenancy. It just gives them the right to cure. If they don't cure within that time, then they're entitled to another 3-day notice to terminate the tenancy. They are not allowed to cure the breach during that second 3-day period. It's just a notice that they need to leave. And only after that can you file an eviction. But also the new law requires notice to the San Diego Housing Commission through what they are calling the San Diego, I have the name on one of my next slides. So the San Diego Housing Commission is in the process of issuing an MOU and receiving proposals for developing this website where the notices have to be submitted. If you use the ERAP website for the Emergency Rental Assistance Program, it'll probably
I have military discount.
So just be aware that there are now 3 notices that need to be issued for any curable breach. Then we have the no fault just cause notices, which are generally your 30 and 60-day notices, or sometimes a 90-day notice. The San Diego regulation is different when it comes to no fault just cause, different from the rent cap and just cause state law, because they added a good faith requirement. So when, for instance, a very popular one is when the landlord or their immediate family member is going to move in. People allege that that reason is often used incorrectly and in bad faith because the landlord says they're going to move in and then they don't. Or they say they're going to move in and they only move in for a very short period of time, and it's just to get the other tenant out. So now there's this good faith requirement, which might be used against the landlord if the tenant can prove that they acted in bad faith. There are slightly different descriptions of the causes that go for no fault just cause, and the notice to the tenant must include relocation assistance, 2 months of relocation assistance for a regular tenant, and 3 months of relocation assistance for a tenant who is elderly or disabled. There is also the requirement that you have to offer them and notify them of their right to renew the tenancy. And that passes the obligation to the tenant to let you know if they're interested in an offer to renew the tenancy. If the property goes back on the market, if the reason is because it was removed from the market and the property is going back on the market within 5 years, you have to offer the interested tenant the right to come back to the property. You can increase the rent to fair market value. You can review them, their credit for their qualifications, and still make an informed decision about whether they'll be a qualified tenant. But you have to act in good faith. And again, there's this notice to commission requirement. Some of the changes to the no fault just causes, I said there's slightly different descriptions of the causes, and I don't have a slide for that, but some examples of that is if the reason for the eviction is that the landlord is going to do substantial remodel. With a substantial remodel, there are now 3 periods of time that have to be complied with. First, the landlord has to provide the tenant with a copy of the permit applications within 3 days of the applications being submitted. Let me make sure I'm telling you this right. So when the applications are submitted, they need to be posted at the property within 3 business days of submittal to the city. And then the landlord has to secure the necessary permits for the demolition or substantial remodel. And only then, once the permits are secured, can the landlord provide the notice to terminate the tenancy, whether that's a 30 or a 60-day. And they have to serve a copy of the permits once they are obtained. It has to be certified under penalty of perjury. So that is a really a very detailed procedure that has to be complied with. Another interesting difference in the no-fault causes is when the reason for the termination of tenancy is that the landlord is going to move into the property. The city has specifically left out siblings from their definition of immediate family member. So the immediate family members are the landlord or their spouse, domestic partner, child by blood or adoption, grandchild by blood or adoption, parent or grandparent, but brothers and sisters are not included. And eventually, for leases, actually, this is in effect, but this is for leases entered into after June 24th, 2023. So that date has already passed. So for new leases since June 24th, if the landlord may want to use the just cause of landlord moving into the property to terminate the tenancy, there must be a clause written into the lease. And so the tenant basically has to agree that the landlord may use that as a just cause for terminating the tenancy. So this is for non-exempt properties only, but this is a term that non-exempt property owners will want to have in their new leases. I've developed a San Diego addendum that has a bunch of these new things included so that we don't forget to add them. And so then we have other just causes that are no fault, like government orders and things like that. But the ones that I just mentioned are the really big changes. Okay, so another big thing to keep in mind is that the city of San Diego has published a new tenant protection guide. And within the ordinance, there is language that must be included in notice to the tenant so that the tenant is informed of the tenant protections. And for properties that are not exempt, these items have to be provided to your tenants no later than September 22nd. So that's the date that is 90 days after this regulation was passed. You can find the tenant protection guide at the San Diego Housing Commission's website. We will also send it to you as a freebie for signing up for this webinar. And I'll send you my written addendum that just has the basic language for the notice to the tenant of the tenant protections. There are a lot of other resources, by the way, on the San Diego Housing Commission's website. And so it is well worth going there and looking at it. There's just a bunch of other guides and resources that could be very informative. You see on this slide, the new notice. This is the text of the new notice. It's just copied and pasted right out of the ordinance. And so you'll also get a copy of the slides and you'll have that language. And we also send out a copy of the ordinance too. Okay, so the city of San Diego new tenant protection law for non-exempt properties. So this is the relocation assistance. We have 2 times the monthly rent for most tenants and 3 times for elderly or disabled people. We did review this. What's important to also know in advance of negotiating any kind of buyout agreement is that this law, we'll go over the buyout agreements more carefully, but this law requires any buyout agreement to the buyout offer must be more than what the tenant is otherwise entitled to receive for relocation assistance. So you have to first know how much relocation assistance the tenant would be entitled to And I suggest offering $1 more than that relocation assistance. And you have to give them a notice of their right to renew and the instructions for that, as well as notice to the San Diego Housing Commission. Did I mention the notice to the San Diego Housing Commission is only required 30 days after they actually get their website up and running. I know I started to mention that they are developing the website. It doesn't exist yet. That compliance issue only occurs after they get the website up and running, and then 30 days thereafter. And so keep that in mind. So the notice of right to receive the offer to renew the tenancy is a period of time for 5 years after the tenancy is terminated. And I believe that the termination of the tenancy has to be on good terms, meaning that you gave the tenant notice and they moved out without being evicted. I think if you have to evict the tenant, that would negate the obligation to offer them to renew the tenancy, even if the notice that you gave them says they have the right to renew the tenancy. Now, I guess we could debate that, but I just think that's probably a safe assumption. But when we assume things in the law, then we're probably going to be debated on that. Okay, so the tenant has 30 days to notify the landlord of their desire to renew the tenancy within the next 5 years. And then the tenant has to follow up with the landlord and make sure that the landlord knows where to find them in the future. If the tenant changes their email address or their mailing address, or they fail to inform the landlord of their mailing address, then the landlord can't find them, and therefore the landlord is no longer obligated to honor their right to renew the tenancy. All right, so just to recap that, here are the majority of the new things. There's a few new things that we'll go over after this slide, but the basic 5 things: the new tenant protection guide and additional notice that must be provided within 90 days for existing leases. And now it's required with all new leases. The new, for exempt properties, leases must claim the exemption. So if you're exempt, your lease has to claim the exemption. Or for now, you can give your tenant a notice of the exemption. That goes on until January 1st, 2024. The new written agreement for the written agreement or clause required for landlords to use the no fault just cause. And this is that they can, if they intend to occupy the premises. So they can terminate the lease unilaterally if they intend to occupy the premises by their spouse, domestic partner, child, grandchild, parent, or grandparent, but not the siblings. So for the new at fault and no fault just causes, there's a notice to the San Diego Housing Commission once they get their portal running. And then for no fault just causes, we have the relocation assistance of 2 times or 3 times the monthly rent, the notice of right to renew, and the notice to the San Diego Housing Commission. So that's a pretty thorough recap of the eviction process as defined in the new San Diego regulation. But we have not yet really talked about buyout agreements. Buyout agreements are our cash for keys agreements, our move out agreements. We're all, I think, familiar with the negotiation with the tenant so that we can avoid an eviction. We offer them a certain amount of cash, and then at the date that they agree to move out, we meet them at the property, we hand them, we walk the property and make sure it's in good condition. There's a written agreement in place. And then as they walk across the front porch, you hand them the cash, they hand you the keys, you can change the locks on site. I do recommend having them sign one more thing saying, I vacated on this date, but that's just my opinion. That's your standard cash for keys transaction. We are very accustomed to being able to negotiate cash for keys freely at any time, but now within the city of San Diego, if you're not exempt, you have to provide the tenant with a disclosure prior to making any offer of cash for keys. The landlord has to have this disclosure signed in writing by the tenant and must maintain it for 5 years. After that, if you reach terms negotiated terms for the buyout agreement, those terms need to be incorporated into another written agreement, and there's specific language that the city requires. It must be signed by the tenant, and this is a form that we just haven't seen before. So I've created some generic forms, I've created my own work product forms, and we've been using them since June. So everybody needs to have these forms in place if you plan to negotiate cash for keys. Retaliation is prohibited under the new law. Retaliation is always prohibited, but it bears saying it. And then here's the really big part of this law, and this is the biggest change. Under the California state law, rent cap and just cause law, there's really not a lot of teeth other than the fact that if you don't comply, you won't be able to get your tenant out. The San Diego regulation has some very specific remedies, meaning these are the damages that the tenant would get if the landlord fails to comply. And these are for any lawsuit filed by the tenant for any violation of this regulation, so that the tenant can sue. That's what private right of action means. They can sue to enforce any violation of the law. They may get an injunction from the court, meaning the court can stop an eviction or stop whatever the landlord is doing that's a violation. The tenant can get equitable relief, that's usually money damages or maybe being reinstated in the property, and punitive damages. So punitive damages could be an amount of money that a judge thinks is, a sufficient measure to make sure that the landlord is sufficiently punished. Or we have treble damages written into the statute. Treble damages is 3 times the actual damages. Treble relocation assistance if relocation is not properly paid. Defense to the eviction, meaning if you're in the middle of an eviction and the tenant identifies a violation, they can stop the eviction or sue you after the fact for wrongful eviction. They can get their attorney's fees paid for, and also the city attorney has the right to enforce the regulations. So all of this is effective since June 24th, 2023. And it's a pretty big change. So I will run through a couple other new laws really quick, just so that everybody is aware of them, but I'm not going to go into any depth, and then I'll come back to questions about the San Diego regulations. So we have short-term residential occupancy licenses, vacation rental licenses. There has been some interesting controversy about how those licenses were issued, and there were many little ways around some of the regulations that seem to be condoned by the city. So I'm interested to see what comes of all of the controversy. County of Los Angeles has new regulations, particularly for notices to pay or quit when a tenant claims a COVID hardship. So this is one place where COVID hardships are still in effect and usable by tenants. We have the Chula Vista Municipal Code. I feel like a lot of people have really, in that area, have been up to date and aware of these. So we are making sure to comply whenever there's a rental in Chula Vista. It's a pretty dense regulation with a lot of also the right to attorney's fees, punitive damages, actual damages, wrongful eviction, private right of action for the tenants. And so it's important to comply with that one. The California rent cap adjustment is meant to happen every May. It actually ends up being in June, and it's written that the rent cap is adjusted based on a number that is published by the Department of the Bureau of Labor Statistics in April. But actually our San Diego numbers are published in March and May, so that's why it tends to come out in June. The calculation was done for, the adjustment is made and goes into effect August 1 to August 1 every year. So August 1, 2023 to August 1, 2024, the rent cap remains the same. It hit the cap, it's 10%. So the rate of inflation was so high that we hit the 10% cap, and so that is still the cap. That's been the cap for the last couple of years. All right, and then just an update on unlawful detainer litigation. When we are filing evictions, we're finding that the courts are setting trial as they're supposed to within 20 days of requesting trial. However, once you get to trial or once you enter a default judgment, the courts are somewhat slow in processing the paperwork. So as of today, clerk judgments, default judgments for possession only they are working on August 8th. 2023. So that's really good. They have really caught up on those. Court judgments that are default judgments for possession and money. So if you want the money, it has to go to the judge to sign. They are working on July 10th. So they're just over a month processing time for those. And sorry, the weeks on this slide are wrong now because it's actually only about 1 week time for the clerk judgments, and it's only about 5 weeks time for the court judgments. Post-trial judgments are really unpredictable. They say that they're working on March 23rd, but we've been getting them a lot quicker than that. That's about, what is that, 5 months, but we're getting them much quicker than that. All right, so good. We've gotten through this in record time. I'm going to look in the chat and see what questions we have.